But now we are joined with Ann Kiguta, who is here to speak to Sharad Rao, who is the chairperson of the Judges and Magistrates Vetting Board. Over to you, Ann.
Thanks very much, Joy, for that. And good evening, Mr. Rao. Thank you so much for making time to speak to us. I know it's been a crazy couple of days for you. And let's start with this. After the High Court ruled against the degazettement of judges that your team found unfit, what do you think the implications of that ruling are to the work that your panel does and largely the reforms that we're seeking in the judiciary?
I think as far as the degazettement, as it's called, of the judges that we found unsuitable, the legal position, as I see it, and I may be wrong, is that once the vetting board, and this is the law, this is the act which specifies that once we find a judge unsuitable and our decision is communicated to him and announced to the public, then that judge is deemed to have been removed from office. That is the legal position. I don't personally think that the degazettement is necessary in this particular cases. This is a unique situation. The vetting is a unique situation with a limited time frame, and the objective behind it is to vet all the judges who were in office on the 27th of August 2010, so that the board is able to assess, an independent board able to assess their suitability to continue or otherwise. And that has to be done before the election, which is on the 4th of March 2013.
And certainly before your term expires, which is in February 2013.
Well, our term doesn't strictly expire. I think we have been asked to complete the vetting of the judges by that date, by the end of February, because that it will be necessary to have all the judges vetted by the time that the election takes place, and we do not have a repeat of the post-2008 situation where people could not go to court because they had no confidence in the court.
There's an interesting dimension that you've added, that once you have deemed them to be unfit, then really they are not holding office, and that's your perspective.
Absolutely.
From the law. But we do know for a fact that they continued to draw salaries, and some would argue that is why the degazettement is necessary, so that they stop drawing monies from public coffers.
Yes, that is the monetary part of it. As far as the vetting board is concerned, we are now functus official, which means that we have nothing to do with those judges anymore. Once we found them unsuitable, once they came before us for a review, and where we, in 2 cases, we allowed the review, asking the 2 judges to come back to us for vetting again, but in all other cases, we refused a review. Once that's done, our job is over as far as they are concerned. Now the ball is in the court of the judiciary, the ball is in court in the President's office. If they wish to degazette them, if they want to stop their salaries for the period from which, on the date on which they were found unsuitable.
And I know by your previous answer, you're also referring to the fact that you gave these some judges the right of appeal to your own body. But the argument is, how fair is it if you're the one who said that such and such a person is unfit to hold office, and then they come back and appeal to you? I mean, how far do they stand a fair shot at getting a proper hearing the second time around?
Yes, as I told you.
And sorry, if I could finish. Yes. And therefore, should there not be another body, such as the High Court, that can intervene?
Well, it is not possible in this particular situation. As I said, it's a unique process and to be achieved within a particular time frame. And it is because of that the drafters of the Constitution saw it fit to insert that clause, which is Section 23, which is being referred to as part of the 6th schedule of the Constitution. It was put there intentionally to avoid a situation and to give a finality to the process, so that once a judge has been found unsuitable, then that should be the end, and that's the final verdict from the vetting board. All the judges who came before us had the option not to come. They had the option to retire before choosing to come before the vetting board. So they knew the stakes were high, and the only possible for them is to come for a review, and the review, I know, is limited. The review is only restricted to any new evidence which was not available, and if there are errors on the face of it, which they can point out to the vetting board. Those are the only 2 situations in which a review can be successful. It may be unfortunate for them, but the situation, the politics, the public interest demands that there should be a finality to this. Otherwise, in a situation such as this, now there are 5 applications before the High Court of these 4 judges plus 1 more. for those 5 applications, therefore, to go through the process, and the process, however speeded up, takes time. Because you have to file your grounds, you have to file a formal application, has to be supported with grounds, has to be supported with affidavit, has to be served on the other party has to respond, the written submissions have to be made, the case argued.
Yes, I see where you're going this. I see where you're going with this. It must be time bound, I understand that. And we are time bound as well. We're just winding this up right now. Do you feel that there are attempts to slow down, to frustrate the process of reforming the judiciary?
I think when one looks at it from the point of view that this is not the first attempt now, there was an attempt in the Court of Appeal when we were stopped for about 21 days from carrying out our work. Then on the 25th of September, we had a stay of 14 days. That stay got extended until yesterday when it was lifted finally by the court. So that is one process where the litigants who go before, I'm not blaming the court, I'm blaming those who have gone to court to frustrate the process. And you can see
no hidden hand behind this.
There are
somebody trying to maintain the status quo.
There are various hands behind it.
Name them.
Well, it's difficult to name them. I think it's not fair to you, it's not fair to me, it's not fair to
I'm sure the country would like to know who's stopping reforms.
Well, you see, I think you can discern from who have gone to court. You can discern from the articles which have been appearing in the newspapers and in the media, which are attacking the credibility of members of the board. Some of them have gone to a very personal level. There is character assassination of members, including myself. Those kind of things does to point to the kind of people who are behind the scene. There are people who are affected, there are the supporters of the people who are affected, and so on.
Being time bound, I'm not allowed to press as far as I would want to, but I'll certainly look for another opportunity if you grant. Thank you so much, Sharad Rao, for speaking to us, the chairman of the Judges and Magistrates Vetting Board. I am Ann Kiguta. Thank you for watching. That's it from me. But stick with KTN. Joy joins us next.